Hi there. Well, as you guys know, I have been going through each of these motions that occurred in the hearing this past Thursday because I think it's good for us to break them down and talk about them a little bit. And so we're going to watch this as it occurred. I might trim some of it out, but also I'm going to make some commentary because I don't like to make commentary while you guys are watching the hearings or the trial. So I like to do this after the fact. So first, let's talk about this motion for cost. This is just him trying to get money from the JAC, which was expected, and it's going to happen. So why even bother getting mad about it?
Now to the defense's motion to appoint forensic psychologist filed September 2, and defense's motion to appoint crime scene reconstructionist and death investigator filed September 2. I did receive JACS's response in that my judicial assistant confirmed that they are not asking to participate in this hearing.
Judge, I have filed the amended motion for declaration of indigency and payment of due process cost.
I did see that, sir.
And then there are three motions. I don't know if you got the third one.
Are you referring to the motion to return property?
No, relating to cost.
I want to show you guys something super quick. If you have not watched my video on the latest crime scene reconstructionist / death investigator, he's got a very colorful past, very unethical charges against him, and I cannot wait until the prosecutor tears him apart in the trial because he has been approved. So this is Dr. Birkeland. Anyway, this video was posted several days ago, so if you have not watched it, I highly recommend you go back and do so. All right, back to the video.
Reflected. So no, I don't.
I filed a second amended notice of hearing. I don't know if you got that.
Was it forwarded to my office? Because if it wasn't, I don't know.
I'll have to ask Margaret. I don't
Margaret.
know.
Okay.
But I filed a second amended notice of hearing. Can I
Please.
get my copy?
Can we just make a note right here that he could have turned to these two lovely ladies, beautiful young ladies, very young ladies, sitting on either side of Sarah Boone, to ask the question of, was this filed, ladies? Because, they probably would have known if they were real paralegals. But I don't think they are. They probably are from Orlando. He probably got them off a Craigslist no, I'm just kidding. I don't know where he got them, and I'm not saying anything bad about them too, as they are. They're very pretty, and that's why they're there. I just find it very entertaining, the fact that in no way, shape, or form during this whole entire hearing do these ladies sitting here do absolutely anything for this gentleman. He is strictly carrying this hearing on his back and his back alone. I call that seat fillers. I call that failed intimidation. Because as you'll see, at some point in time, you're going to look over, you're going to get a glance of poor Mr. J over there at the prosecution table, sitting there all by himself. He's just sitting there like waiting for his turn to speak. He knows what he's going to say. He knows what Owens is going to throw out there. He's completely ready for it. And even though Owens is starting to bring up new stuff, the state's they're ready. Bring it.
Judge, what I had done was
Don't see a date on here, Counselor. When was this sent? The certificate of services contains no date.
Do y'all know? Do y'all know?
It was filed this afternoon.
Margaret.
Okay.
Margaret, when was this sent, Margaret?
All right, what is the other?
It's Dr. Julie Harper, and it's non-pro-tunc. I'd like it to be. I asked Dr. Harper to go down and see Sarah Boone. Dr. Harper lives in Okaloosa County, and she came down to Orange County, I believe, the Thursday after we had the hearing on September the 3rd. I believe that's when the court denied my motion to continue. And so, as you know, we had to file the notice of intent to rely on battered spouse syndrome within 30 days prior to trial, which would have been that Saturday, I believe. So she went down, Dr. Harper went down and saw Sarah again. As you know, Dr. Harper had seen her several times early on in the case, back in 2020, maybe 2021. And so she had the most knowledge of, I believe, any of the experts that have evaluated Sarah Boone over the course of these 4.5 years. She was the one expert that had seen her the most. I asked her to go down again in the hopes that the court would appoint her. And she agreed. That was, I think, on a Thursday. She called me that morning, Friday morning, and said, yes, I do believe that she suffered from battered spouse syndrome at the time of this offense. Based on that, I filed the motion. But so she jumped ahead and did some work prematurely before she had been appointed. So I'm asking for those costs for her to do the earlier work, that be considered, as well as Dr. Berkland. Dr. Michael Berkland is a crime scene reconstructionist and death investigator, and I'm asking for the court to consider paying for his fees as well as his transportation costs, as I have for Dr. Harper, again, to be retroactively to the time I asked him to begin work on the case. And then the last...
When was that? You're asking Nunk-Pro-Tunk to win on that, also to the August 30th date of your
Yes.
appearance?
If possible, yes.
Just God forbid, don't let him touch the body.
That's when I officially got on the case.
Okay. Now, as to the third motion for costs, I don't have a copy of that, unfortunately.
Can I approach?
Yes, please.
You'll see how hard he's working up there all by
Judge, I
himself.
mentioned this expert, Dr. Michael Brannon, in that hearing that I think we had on September the 3rd.
Okay, Dr. Michael Brannon. So this is the guy you see on court TV all the time. In fact, I did a little bit of history on him, and let me tell you what I found. I mean, he seems like a very well-established individual or doctor in his field. He seems very highly sought after, but he does a lot of TV. I've got a clip here that I want to show you guys of when he was on court TV speaking on this case. Everybody's been up in a hubbub about that. We're going to watch that in just a second here. He testified in the Marsha Thompson case, and he testified on the defense side. And then also he spoke, I found previous clips of when he spoke on Jody's Arias, Marissa DeVoe, is it Devereaux? Jerry Sandusky's trial, the Oscar Pistorius, I forget his name, Isabella Martinez, some big profile trials that he spoke about when he was interviewed in the media. Not that he did these particular cases that I'm aware of. He did testify for the prosecution, though, in the Nicholas Cruz trial, and that was the Parkland school shooting. But again, he testified for the prosecution, not the defense on that one. And it was a different kind of trial, but I haven't done a total deep dive on this guy. I don't think there's a whole lot to find on him. I think he's okay. I'm surprised that he's willing to do it. Let's hear what he said on court TV really quick about this case.
He says during the meetings, they discussed exculpatory evidence on her phone, which they hope will potentially corroborate her battered spouse syndrome defense. Dr. Michael Brannon, this is where I want to bring you in. We all saw you testify in Marsha Thompson's case, and you were really the star of that trial, the breakout star of that trial.
Yeah, I wish we could have seen it. I've looked everywhere for that clip, you guys. If you find the clip of him testifying in Marsha Thompson's trial, please send it to me because I cannot find it.
Looking at this case, and I know you haven't personally evaluated Sarah Boone, but based on what you know and the facts we see them, do you think she could be successful on a battered spouse syndrome defense?
Well, good morning, Julie, and Melba, too. Good morning. So it's a very difficult defense, even when everything is all put together nicely for the defense to occur. And there has to be a number of different elements that fit in order for the battered spouse defense to be successful. And in this particular case, you know, there's a reason why people go through a lot of different attorneys. Some of them may just be stall tactics. Some may be trying to establish a certain defense. But attorneys may be, and again, I didn't talk with her. I don't know that much about the case. But attorneys may have already told her, listen, you don't meet the elements of this, or this is not going to be successful, trying to give her the benefit of their legal knowledge and background. And she may not have been willing to accept that. She may have heard from other inmates or family members, or she may have seen court TV and thinks it may be a good idea, but the facts of that, the elements may not apply directly to the case.
Dr. Brannon, let me go back to you, please, on the issue of battered spouse syndrome. Sarah Boone, we know, is a very strong-willed, shall we say, woman who seems to know what she wants. She had difficulty getting along with the 8 prior attorneys. Maybe 9 will be lucky number 9, who knows. But tell me, if she is intent on going forward with this defense, or at least exploring it, what does that look like from your perspective in consulting? Would you kind of take us behind the scenes? How would that go?
Sure. So you'd want to know right away whether there's any control tactics that were being done by the victim in this case. Was there a pattern of abuse? Was it ongoing? And was the individual, the victim in this case, so controlling that she wasn't allowed to contact, be in touch with other individuals, be in touch with family members to try to get help? And did she make other attempts to try to get away from the abuse? And I'd also note that the method of death here that was utilized by Ms. Boone on the victim, it would be unusual for a battered spouse case. Usually the actions are impulsive, they're quick, a quick gunshot or a quick stab wound. But this type of killing is really unusual and almost unheard of for battered spouse cases. So they'd have to overcome that as well, because it appears that there's some thought, some intent, but also some lingering time for her to think about what she's done. And oftentimes those are not synonymous with battered spouse defenses.
Okay, so he's coming in as a forensic psychologist. That's what they're appointing him as for this case. So what does a forensic psychologist do? According to Faulkner University, a forensic psychologist studies the behavior of people who break the law and uses this knowledge to help law enforcement. A forensic psychologist is a qualified specialist who uses their knowledge to connect psychology and the legal system. Contrary to the common misconception, forensic psychologists don't always work at the crime scene or catch criminals. They usually focus on studying criminal behavior to help law enforcement officials understand the offender's mind. I want to go back to these questions that he was just going over here. Now that I've defined a forensic psychologist and you guys know what he's doing.
Sure. So you'd want to know right away whether there's any control tactics that were being done by the victim in this case. Was there
control tactics by the victim? Yeah, we have those with Sarah. Okay, go ahead.
a pattern of abuse? Was it
Pattern of abuse by Sarah? Yes, there was. Yes, there was by Sarah.
ongoing? And was the individual, the victim in this case, so controlling that she wasn't allowed to contact, be in touch with other individuals, be in touch with family members to try?
Oh, you mean like when George is on the phone with his brother Juan and Sarah's in the background screaming and yelling to get his attention that she's got to call his brother and that he beats her and everything? Is that what you're talking about? He beats her and everything, telling his family. Oh, remember when he had his brother Mo beat him up because Sarah was screaming at Mo about how George beats her up all the time? Once again, she's out in public, so she's telling everybody what a shit boyfriend she has so that they can all think that she's wonderful. This woman is a psychotic fruitcake.
To get help? And did she make other attempts to try to get away from the abuse?
Okay, well, nope, she didn't. See, what happened was, Dr. Brandon was, she had several chances to do so if she really felt like she was being abused. I think, if anything, George was trying to get away and he couldn't. He went and lived with his mom for quite some time. Somehow or another, she kept calling. And that was something that Juan said in his interview. He says, George's brother says, that she kept calling and bringing him back. I believe even Brian stated the same thing. She kept going back, or she kept bailing him out of jail. So when she would have him put in jail, she would bail him out. So there were many circumstances where there were times when he was in jail and she could have kept him in jail. However, she would go back to the prosecution the day after or whenever it was. She'd go to his defense attorney and say, I don't want to prosecute. I'm not going to cooperate with prosecution. And so they'd have to drop the charges, which is what they did in almost all of his cases except for the one. So to say that she didn't have a chance to get away. Wait, what was your question again? I'm sorry, I got sidetracked.
And did she make other attempts to try to get away from the abuse?
No, I'm sorry. To answer your question, no, she did not.
And I'd also note that the method of death here that was utilized by Ms. Boone on the victim, it would be unusual for a battered spouse case. Usually the actions are impulsive. They're quick. A quick gun.
I wish y'all could see the look on my face right now. He's saying right there, it doesn't set up the battered spouse syndrome, because usually the battered spouse gets to the point to where it's like, this is my one and only chance. I got to do what I got to do. This is more calculated, what was done here. Let's go back a little bit, and I want to go.
Usually the actions are impulsive. They're quick. A quick gunshot or a quick stab wound. But this type of killing is really unusual and almost unheard of for battered spouse cases. So they'd have to overcome that as well, because it appears that there's some thought, some intent, but also some lingering time for her to think about what she's done.
All right. So first things first, will prosecution ask him about this interview on the stand? Can they bring that into question? I don't see why they can't. But he's right. I mean, he's absolutely right. But he's going to have to twist his story around in court to make it sound a lot better than what he just said. It'll be interesting.
Oftentimes, those are not synonymous with battered spouse defenses.
Oh, I'm sorry. I left out the best part.
You have to overcome that as well, because it appears that there's some thought, some intent, but also some lingering time for her to think about what she's done. And oftentimes those are not synonymous with battered spouse defenses.
Not looking good, Jamie.
A clinical psychologist, if you'll recall, I'd mentioned him. He had served as an expert in the Marsha Thompson Palm Beach County case.
I recall.
And so, as you know, he serves a different role as a clinical psychologist. Dr. Harper is serving as a forensic psychologist. And
do you know what JACS's opinion with regard to the motion to appoint clinical psychologist? Because the email that you attach as Exhibit A to that appears to be Mr. Lake's email regarding the other two motions regarding Dr. Harper and Dr. Birkland. And it doesn't address Dr. Brannon, and notably JACS isn't here.
I don't have an answer for that. Maybe we could table this.
I think the state has, I'm assuming, no dog in this.
Maybe you could be a little bit more prepared when you come to court, Jamie. You know, he said he shut down his law practice to work on this case, right? He's had nothing else to work on. And he makes himself out to be such a big deal, right? But when he gets up here in court, it really shows that he's like a one-man show. Because where has all his time gone? I mean, the time that he spent out giving interviews and whatnot, he could be researching these expert witnesses, getting this in order, researching all the case law and all that so he could put this in front of the judge. It doesn't seem like that seems to be a priority for him. And if he were my defense attorney, I would want that to be. Now, we do know that he's gone and looked for some witnesses that he's been unable to find. He's going to talk about that here in a minute, but he's bitten off more than he can chew.
Fight similarly as they had with the other two.
The only request in this area that the state is going to make of the court is to, under its discretion under 3220, order these experts to produce written reports. We are on the eve of trial. I do not need one from Dr. Julie Harper. Her deposition is set October 1st. These two other people, I have absolutely no idea what they are going to say, and we would. I'll file a written motion and a proposed order and send it to opposing counsel. That's what the state's request is going to be on the other two experts.
Yeah, I don't know if I'm going to have an objection to a written report or not. I may, but I'd like to see what the motion says before I make a decision. But yes, Judge, we have scheduled Dr. Julie Harper's deposition at her office in Okaloosa County on Tuesday, October the 1st at 10:30 a.m. Eastern Standard Time.
Is that in person or is that virtual?
Central.
Is that in person or is that virtual?
I believe
Okay.
the state's flying in, and I'm going to be there, Judge. That's the county over from me, Santa Rosa County. So about an hour drive for me. So I'll be there in person. We're going to have probably Kevin Beck that's going to appear by Zoom.
Is Kevin
so
Beck
here's what
ever
we're gonna
going
do.
to not appear by Zoom? Kevin Beck is way away from what I understand. Where did we say he lived? I forgot. We saw his address at one point, and I was like, what the hell? Is he going to appear via Zoom, you guys, or do you think he'll fly in? He's got to fly in for trial if he's going to do something on this case. And what piece of it is Owen going to have him do? Because we haven't really seen that yet. I guess maybe it's this piece with the doctor here, Dr. Harper.
JACS has provided their response, and their response was not appended to the motions that were filed because that was prior to the amended motion seeking indigent costs that you filed, Counselor, on behalf of Ms. Boone. I'm going to hand file with the court now the September 9th correspondence from JACS reflecting that can be utilized in lieu of a formal response. I'm going to grant your motion to appoint a forensic psychologist dated September 2, 2024, non-protunct those costs to August 30, 2024. And with regard to the other motion, the motion to appoint crime scene reconstructionist and death investigator, I will also grant that and appoint Dr. Michael Berglund, non-proton, to August 30, 2024. With regard to the motion to appoint clinical psychologist, when was this motion filed? Similarly, the certificate of service does not reflect a date.
Let us check
What?
real quick. Judge.
Sure.
Give me a minute.
Yeah, why
Yeah,
is
good.
it not filled out? Margaret, why isn't there a date on there? Somebody call Margaret.
Let us check real quick. Judge.
Sure.
Give me a minute.
Yeah, you're good. Excuse me.
She's like, I think there's something on this computer over here you might want to look at, but I don't know what it's for.
No. Michael Brown.
No,
It had to be filed.
no, you freaking blonde. That's not it.
Michael Brandon.
We're looking for Brandon. Look it up.
While you're waiting on that, I do see on your second amended notice of hearing, you also requested the amended.
And they're going, you know what? You just told us all we had to do was sit here and shuffle papers. You didn't tell us we were going to have to look anything up on the computer. And Sarah's like, oh my God. Why do we need this guy? Just tell him it wasn't intentional.
Motion for declaration of indigency and payments of due process costs also be heard. When was that motion filed as well, Mr. Owens?
It was filed just prior to filing these amended ones.
He doesn't know.
It had to be filed prior to my motions for appointment of these experts.
He has no idea. Margaret,
Second.
get Margaret on the phone. Do you know how? He's going to turn to that blonde. Do you know how to dial a cell phone? Call Margaret. Do you know the number? God, let me give him my business card. You can call. I'll use my business card. I bet you he went out and had a scotch after this and was cussing his head off. Because he was on TV. What are we doing? What are we doing?
Okay, so the motion to appoint the clinical psychologist regarding Dr. Brandon, was filed yesterday. The amended motions regarding Dr. Berglund, an amended motion regarding Dr. Harper were filed yesterday, as was the amended motion for declaration of indigency and payment of due process costs. That motion has not yet been granted. It is going to be. So the amended motion for declaration of indigency and payment of due process costs is granted. The amended motions regarding Dr. Berglund and Dr. Harper are also granted, non proton, to August 30. With regard to the motion to appoint clinical psychologist filed 9/18, I'm going to ask Ms. Barrios, my judicial assistant, to forward that directly to Mr. Lake. And I know that she's watching this virtually. If she's able to do that now, I would greatly appreciate it, and see if we can get his response to that this afternoon. And maybe we'll be able to address that. It may be a similar vein as to the prior response that JACS had provided.
And the defense got a win. Well, bless their hearts.
Moving now to the defense's motion to appoint forensic psychologist filed September 2, and defense's motion to appoint crime scene reconstructionist and death investigator filed September 2. I did receive JACS's response in that my judicial assistant confirmed that they are not asking to participate in this hearing.
Judge, I have filed the
Wait, did y'all see him? Let me take this off. Hang on. Look at him over there by himself. Mr. J sitting over there by himself going, oh, good Lord.
Hearing.
Judge, I have filed the amended motion for declaration of indigency and payment of due process cost.
I did see that, sir.
And then there are three motions. I don't know if you got the third one.
Are you referring to the motion to return property?
No, relating to cost. Relating to
Don't
cost.
know that I have. I'm just going by what the notice of hearing reflected. So no, I don't.
I filed a second amended notice of hearing. I don't know if you got that.
Was it forwarded to my office? Because if it wasn't, I don't know.
I'll
if I've
have to
got it
ask
yet.
Margaret. I don't
Margaret, somebody call Margaret.
know.
Okay.
But I filed a second amended notice of hearing. Can I
Please.
give you my copy? Judge, what I had done
Don't
was
see
I
a date
had,
on here, Counselor. When was this sent? The
Margaret.
certificate of services contains no date.
Oh, shit, Judge. I don't know.
it was filed this afternoon.
You see what I'm saying? He doesn't look at the girls. He didn't look at the girls to see what was filed. That because he knows they don't have any freaking clue of what's going on. He's doing everything with Margaret over the cell phone. He's texting her now, probably. Or he's looking through his emails, maybe. And we know that the JAC came back on and they approved it. He got a win on all of those little motions for his little experts. At the hearing, the JAC came on via Zoom and approved it all. Christian Lake did. Since this hearing has occurred, the ASA did file a motion to state that they wanted to see all of the reports from these expert witnesses by a certain date. Actually, it was before this coming Thursday, before the pretrial conference. All right, let's move on to the portion that I like to call that damn phone. This is the motion of return of property.
To the motion for return of property, or in the alternative, motion for independent exam by the defense, filed September 18th. Similarly, with everything else, I've reviewed that and the authority, and I have reviewed the state's response to a defendant's motion for return of property, or in the alternative, motion for independent exam by the defense. Mr. Owens, you may proceed, sir.
Judge, I believe the state's response is well taken. And I believe that what we need to do is get an expert of our own that can do the phone extraction and meet with the state attorney and the sheriff's department and extract the data, all the data that we need from her phone.
Okay, I just want to say one thing here. This is a big deal of what he's talking about doing, because we don't know how long she's had that cell phone. If she's like me, she doesn't buy a new cell phone every time they get updated. I mean, what is on that cell phone? It could be like you've heard Sam talk about it. It's pages and pages and pages. Every text, every emoji that's ever been sent comes out on this report. It is a big deal. It is a lot to do. So how in the world does he think he's going to get all of this done before trial? It's in time for them to sit down and review it, go through it, and work out the points and the parts that are important. Maybe that's what this expert will do for him.
So we would submit that the property should not be, based on the authority the state attorney has cited, the property should not be returned to the defendant since trial is still pending. But in the alternative, we're asking for an independent exam by the defense.
And two, that they had already downloaded a bunch of stuff. Now, what we had said before is possibly the state only downloaded the portions of the phone that they needed. They didn't download the entire thing. I don't know. I kind of think that they downloaded the whole thing. But again, you're talking about this was all done back when another attorney was on it. And we don't know if this, it was Padilla. Owens had mentioned that he couldn't get Padilla to return his phone call. Now, as you guys know, Padilla was like the first guy on this, right? Let me show you something really quickly. So this is the report I got from the JAC. And this is just the portion dealing with the forensic side of it. Now, if you're looking to look at this whole report of what the JAC has paid and everything, this is the thumbnail I have on that. I think I had it over 80 grand. No, I think I had it at 71,400 at that point. This was through August the 28th of 2024. So I would have posted this video towards the end of August. Okay, if you're looking for it to go back and look at it. What Padilla did was, this is in the forensic portion, and the media analysis is the portion that is under Forensic Data Corp. Forensic Data Corp got some mega money. You're talking, let's see, 9, 10, 11, 18. They probably got over 20 grand that's already been paid to them. These are the hours. 36 hours, 11 hours, 33 hours, 18 hours that they've already put in under Padilla's time, that he was on the case, of doing the phone extraction and dealing with that. Now, you're going to hear in a minute that the judge is going to refer him back to this person, John Sawicki, who is the forensic data consulting, under Padilla's bill that he did to the JAC that's already paid for all of these downloads.
Response, if any?
As the state has stated in open court while she was pro se, that is absolutely fine. And I've even suggested a name.
Has the defense ever performed an evaluation of the phone? And the reason I ask this is there were prior experts that were appointed in the realm of electronic evidence.
Mr. Cacciatore may have the answer to that question. I don't, but I know that the state, as I stated in my response, we've never prevented anybody from doing that. And as the homicide supervisor, everybody in the unit knows how to go about doing this and allowing a digital forensics examiner hired by a defendant to go and work with the law enforcement team to get another imaging if they are not satisfied with the imaging that's been provided.
There has not previously been a forensic exam of that phone by a previous defense counsel.
Okay, all right, thank you very much, sir. There was a John Sawicki that was appointed back in, not appointed, authorized back in 2020 as to electronic evidence. So I'm going to deny the motion for return of property based on the citations contained in the state's response. And I'll leave it up to you, Mr. Owens, to do what you need to do in order to have that review.
Okay, I just looked at it again. I was looking at my report again. If you look down here at the bottom, John Sawicki worked for Forensic Data Corp. J.D. Thomas was the other guy. So this is Forensic Data Corp. It was these four that I was just showing you guys. Yeah. So something's been done. I don't know why the state would say that nothing was done. It could have been done. It probably was done before Cacciatore got on the case. And that's why he doesn't know. Because Cacciatore wasn't on the case the whole time that Padilla was on it. He came in a little bit later on. So that could be why he said no. They didn't do anything yet.
All right, I'm going to do my best. We got about 18 days.
Do my best, Judge.
I'll cite to the parties for their own benefit. There were motions, specifically defendant's motion to appoint an electronic evidence expert and order the Justice Administrative Commission to pay costs. It was filed back on May 5, 2020. An amended motion was filed the next day, May 6th. Both of those cite to or refer to John Sawicki, S-A-W-I-C-K-I, electronic evidence expert. And there was a order entered back on August 3, 2020, appointing Mr. Sawicki as a forensic specialist. I have no idea.
And another thing, too, is that Billy Lane from Prison Break Investigation already knows this stuff. He's already knows what's going on. I don't understand why Owens is not leaning more with Billy, leaning on him more to find this stuff out. It doesn't seem like there's a whole lot of communication going on there.
If that order is still viable, but I'm just providing what the court file reflects in that regard.
So basically, you got denied. You don't have time to do all that. You need to go back and see what else has been done already, and then we'll deal with that in a little bit, okay? Okay. I'm going to do you like you just did me. We'll talk about that in a little while. We ain't done that yet. We're not ready to talk about that yet. Thanks for watching, everyone. If you enjoyed this video, please do not forget to like and subscribe on your way out, and feel free to leave a comment. Have a blessed day.